Good morning, everybody. Welcome to our webinar, another in our series of in-house in-focus webinars. And this morning, we're going to be talking about security. We're going to adopt the new policy of just starting on time and let people join in. So I'm James Kidd, as you can see on the screen. I'm your chair for today. I happen to be a partner in our employment team, but I will be your guide into this subject and hopefully ask some lay questions to get the best out of the subject. We're going to be covering security enforcement today. It'll be about 45 minutes. When you leave the webinar at the end, there'll be a pop-up with some feedback. We'd be really grateful if you could complete that. The webinar is being recorded, and we'll send out a link to it later. If you'd like to get in touch with us, we would love you to do so. Please use the Q&A function, and we'll take questions as we go through if they are pertinent to the subject matter. If not, we'll do it at the end, and I'll interrupt the speakers as necessary. So I think that's enough from me, other than two final things. One is you can see on the screen some QR codes. If you'd like to connect with any of us, get your smartphone out, get your camera out, and you can do a quick QR code reader. But enough from me. I'm going to allow Morgan and Tim to introduce themselves, and let's start with Morgan.
Hi guys, I'm Morgan Bowen. I'm in the restructuring and insolvency team, senior associate in London at M&R.
Good morning, everyone. Equally, I am part of the same team as Morgan in London, part of the restructuring and insolvency team. So my name's Tim Evans, and I am an associate and work alongside Morgan on various matters.
So I'm going to be talking about security and its enforcement, key principles you need to know. Yeah, just to go through the topics. So we're going to talk about different types of security, first of all, fixed versus floating charge. Then we're going to talk about the payment waterfall in insolvency. And then we're going to look at receivership versus administration, the differences between these two procedures. And then I'm going to take a back seat and Tim's going to take over, and he's going to talk about challenges to security and tips for debtor directors in a security default situation. So if we can move to the next slide. So here we have the various different types of security you're likely to come across. We have mortgage or charge. And here you need to distinguish between a fixed and floating charge, which I will come on to in greater depth later on. Then you've got trust arrangements, which is fairly straightforward, holding an asset on trust for different beneficiaries. Then you have the pledge. The key feature of a pledge is that the creditor takes possession of the asset as security, and the creditor obtains a legal proprietary interest in the pledged asset, even though it does not obtain title to the asset. And then you have a lien. Now, rather than being granted or taken, a lien generally arises by operation of law, although liens can be created by contract. Liens operate through possession of the asset again, but where created by contract, the difference with a pledge is that the creditor has possession of the asset for a purpose other than by way of security. One other thing that I've accidentally missed off there is also retention of title. So you can have situations where you are a trade creditor, you pass an asset to your debtor, but you retain title in it, and that's another form of security you can obtain. If we can move to the next slide. So here we have the fixed and floating charge distinction. And this is a key concept in kind of security and its enforcement. The key differential is that assets subject to fixed charge security remain under the control of the secured creditor, whereas assets subject to floating charge security can be disposed of by the debtor in the ordinary course of their business. So control is the key here. Is the asset under the control of the secured creditor, or can the debtor dispose of it in the ordinary course of its business? The key issue is not what the documents say, but what happens to the asset in practice. So what is the consequence of that? The fixed charge enables the secured creditor to appoint a receiver on an event of default under the security. The floating charge enables the secured creditor to appoint an administrator on an event of default under the security if the floating charge is a qualifying floating charge, QFC. And I will come on to the definition of what a QFC is in a moment. Now, the main advantage of the fixed charge is the payment waterfall position in insolvency. Basically, the fixed charge creditor gets paid before the floating charge creditor. The other main advantage is that the fixed charge creditor can appoint a receiver, and the secured creditor has a lot more control over a receiver than over an administrator. The main advantage of a floating charge is that the asset can be disposed of in the ordinary course of business, allowing greater flexibility to the debtor in the running of their business. The other advantage is that the floating charge creditor with a qualifying floating charge can appoint an administrator rather than a receiver, while the appointing creditor has less control over an administrator than over a receiver. The administrator has a number of additional powers that can be helpful that I will come on to in a minute. Now, there was an attempt to have your cake and eat it in regard to certain charged assets in one line of cases. This line of cases concerned book debts, wherein under the security documentation, the book debt was defined as being a fixed charge asset until it was collected in, but then on collection became a floating charge asset. So on the debtor's insolvency, the idea was that the uncollected book debts would constitute fixed charge assets to the benefit of the secured creditor, but prior to insolvency on collection, they would be floating charge assets, which the debtor could dispose of in the ordinary course of its business, kind of like having your cake and eating it. This attempt was shot down by the court in Spectrum Plus and in Brewmark. The court in those cases held that the ability of the debtor to collect in the book debt meant that it effectively had control of this asset, such that it was properly analysed as a floating charge asset even prior to its collection in. But there are other attempts in security documentation to create hybrid floating charge / fixed charge rights, e.g. through the use of mirror accounts and the like. I can't go into detail on that here. That's outside the scope of this talk, but it's something to bear in mind. If we can move to the next slide. So this is the critical payment waterfall in insolvency, in an administration or in a liquidation. And just going through it, first of all, we have the fixed charge realizations, less the costs of realizing those assets, which can be agreed by the secured creditor. So the key point here, obviously, is the fixed charge creditor gets paid out right at the start. Then you have the administration or liquidation costs and expenses. Then you have the preferential creditors. And importantly here, obviously that includes the employees for certain debts, but also importantly here, the HMRC has become a preferential creditor again from December 2020. So previously it was a preferential creditor, then after the Enterprise Act reforms in 2002, it got deprioritized. It's been reprioritized for certain debts from December 2020. So that means the pool of preferential creditors is enlarging. Then we have the prescribed part. This is a part carved out of the floating charge asset realizations, which is set aside for unsecured creditors. And this was introduced by the Enterprise Act 2002 because it was felt that the return to unsecured creditors in an insolvency was very poor. And they felt that there should be some part of the floating charge assets, a small part, set aside for unsecured creditors. So that's the prescribed part. It's been increased from 600K to 800K for floating charges created after the 6th of April 2020. Next, we have floating charge realizations. The floating charge creditor gets paid next. Then we have the unsecured creditor for the balance of their claims after the prescribed part. Then we have interest on the preferential and unsecured claims. And then finally, we have the shareholders. Obviously, in an insolvent scenario, the shareholders never get paid. There are exceptions. Lehman happened. The shareholders got paid out. But I mean, that was essentially because of massive, obviously, state support. So the key point is that the fixed charge creditor gets paid out at the top of the waterfall, but the floating charge creditor is much lower down, below liquidation costs and expenses, which can be very considerable, below the preferential creditors, which have, as I said, expanded since December 2020, and below the prescribed part carve-out for unsecured creditors. So the lot of the floating charge creditor is not a happy one by comparison to the fixed charge creditor when it comes to the payment waterfall. Most importantly of all, the lot of the unsecured creditor is even worse. So the outcome in insolvency for unsecured creditors is often nothing at all. And this is means it's important for creditors, if trying to protect their position, to take security or to find other ways to protect their position, for example, through retention of title rights, or just through good financial hygiene, not becoming a creditor to a single debtor in a large amount. So if you can move to the next slide, please, Tim.
Well, before we do that, Morgan, so you mentioned that HMRC has become a preferential creditor again.
Yes.
That sounds like that's bad news for other creditors. What effect is that going to have on security enforcement?
Well, first of all, it has a big effect on the payment waterfall itself. So HMRC come in for a large amount of debts into that payment waterfall and get paid out in preference, not in preference to the fixed charge creditor, but in preference to the floating charge creditor. And so that weakens the floating charge creditor position further. I think the other consequence is that it will give extra rights to HMRC in an insolvent scenario. In particular, for example, a CVA, a company voluntary arrangement, which you often see in retail scenarios on the high street. You're not able to affect it through a CVA the payment position of preferential creditors. And so this will give HMRC considerably more rights within a CVA scenario than they previously had. And it may mean, depending on the position that the HMRC take on these things, that the CVA is no longer, that we've seen so often in the retail sector, is no longer so attractive. And it may mean that we see less of it. Having said that, we don't really know what the position of HMRC is at the moment, and obviously there's obviously the government is trying to minimize the number of formal insolvencies as possible to protect the economy. So it's a bit of a wait and see, I think, on that.
Okay, thanks.
Thanks, James. Just moving to the next slide. So we have a fixed charge receiver, the principles. So these are the fundamental principles. Just to bash through this to give you a concept of the receivership versus administration and the different powers in each. So the power to appoint receivers is usually contained in the security document, failing which receivership powers are contained in the Law of Property Act 1925. It is possible for the secured creditor to go into possession of the charged asset itself rather than appointing a receiver, but the receiver has the advantage that it lowers liability risk for the secured creditor, since the receiver acts as agent of the debtor and not as agent of the creditor. So receivership is therefore usually preferred where the secured creditor desires things to be done to the charged asset other than mere sale. So for example, development. As regards appointment, assuming there's been a facility default, demand is made in accordance with the facility terms. The debt is usually accelerated. The debtor is given a very short time to pay, a couple of hours, for example. Assuming no payment, the creditor then sends a deed of appointment to the proposed receivers who accept the appointment by letter of acceptance. There is no court involvement in the appointment at all, which makes it a bit simpler than administration. And the receiver's principal duty is owed to the creditor that appointed them. So this is a big difference from administration, where the administrator owes their duties to the creditors taken as a whole. The receiver owes their primary duty to the secured creditor that appointed them. As a result, the administrator is not able to prioritize the secured creditor's interests over the other creditors in quite the same way as a receiver can. So if you can just move on to the next slide for administration principles. As here we have the fundamental principles of administration. So it's available to a secured creditor, one, if it has a QFC, qualifying floating charge, that has become enforceable, and two, the administration has a reasonable prospect of success. There is therefore no requirement to show that the debtor is insolvent. A QFC is a floating charge over the whole or substantially the whole of the debtor's assets that purports to permit appointment of an administrator or an administrative receiver. Appointment is done by filing documents at court. Unlike receivership, the court is involved and the appointment process is a bit more complicated, but there is no court hearing. The debtor itself and its directors can also appoint an administrator, provided the debtor is insolvent and the administration has a reasonable prospect of success. So there's an insolvency requirement for a debtor appointment, but as with the QFC appointment, there is also a requirement that the administration must have a reasonable prospect of success. But when appointing the debtor or directors must give 5 business days notice to the QFC holder and the QFC holder can then appoint their preferred administrator rather than the administrator desired by the debtor. So the QFC holder has ultimate control over the identity of the administrator. Once appointed, the administrator is appointed over all of the assets of the debtor, not merely the fixed charge assets as with the receiver. And as previously noted, the administrator's principal duty is not to the secured creditor that appointed them, but to the creditors as a whole. So moving on to the next slide, we have receivership versus administration. So this is just a slide that sort of summarizes the differences between them. The receivership appointment process is a bit simpler. It doesn't require court. The administration process is not that complicated, but it requires obviously the involvement of an administrator who agrees that there's a reasonable prospect that the administration will be a success. So and it requires notifications to be filed at court. The receiver's principal duty, as noted already, is owed to the appointer or appointing them. The administrator's principal duty is owed to the creditors as a whole. Now, in the old days, that was not the case, as the secured creditor was able in the old days to appoint an administrative receiver under a QFC, under a qualifying floating charge that had become enforceable. That administrative receiver would act in a similar way to a fixed charge receiver, in that their fundamental duties were owed to the secured creditor appointing them rather than the creditors as a whole. That was considered to be unfair on unsecured creditors because the realizations in administrative receivership were so poor and it was so skewed towards the secured creditor. And administrative receivership was abolished by the Enterprise Act 2002 and replaced with administration. So now a QFC holder with an enforceable charge can appoint an administrator, but not an administrative receiver. But importantly, the Enterprise Act did not abolish fixed charge receivership. So where a fixed charge has become enforceable, the fixed charge secured creditor can still appoint a fixed charge receiver. So in a fixed charge receivership, unlike administration, the appointer dictates the strategy. They approve the fees. They have much more control over the process. Whereas in administration, because the principal duty is owed to the creditors as a whole, they have much less control. But even in fixed charge receivership, it is the case that the receiver is in office, not the secured creditor. In a fixed charge receivership, the receiver is appointed over only the charged assets. The administrator, by contrast, is appointed over all of the company's assets. The administrator, unlike the receiver, has the ability to sell the floating charge assets without the secured creditor's consent. But the administrator does not have the ability, even the administrator doesn't have an ability to sell fixed charge assets. They either need the secured creditor's consent for that, or they need a court order. Another point there is the final bullet on the slide. The administrator has considerably more powers. So they have much greater statutory powers of investigation into the company's affairs. They have a much easier international recognition, even post-Brexit, because effectively administration is a collective remedy for all the creditors as a whole, whereas fixed charge receivership is deemed to be a secured creditor remedy. And therefore international recognition of the procedure around the world is easier. Administration brings a moratorium on creditor action, which moratorium even prevents a secured creditor's appointment of a receiver. So it's much more wide than the moratorium in, well, there is no moratorium in receivership. So the relative merits and demerits of fixed and floating security mean that in many corporate situations, the creditor will seek both a fixed charge over assets that are capable of being subject to a fixed charge, so as to permit the appointment of a receiver if required, and a qualifying floating charge over the rest of the assets, so as to permit the the appointment of an administrator, so as to give sort of maximal flexibility to the secured creditor in the event of default. So that's a very quick run through the fundamental principles of receivership and administration of fixed charges and floating charges. I will now pass on to Tim to talk about challenges to security.
Okay, lovely. Thank you very much, Morgan. Yes, so Morgan has very kindly summarized the different types of security and some of the pros and cons of each type. I'm looking at the other end of the life cycle, where unfortunately the company has gone into financial troubles and an administrator or a liquidator has been appointed over the company. And as part of their appointment, they're going to be looking back and looking at the transactions that the company entered, and they're going to be investigating whether there are some reviewable, also known as antecedent transactions. And the importance of this is they may, if they find such transactions, they are likely to challenge them, and if they're successful, then that transaction can be undone. Now, if that transaction, for example, involved granting security, suddenly that creditor of the company, which had the benefit or a fixed or a floating charge, suddenly becomes unsecured. And obviously the importance of that, if we think back to Morgan's slide on the payment waterfall, is suddenly they go from being paid 100p in the pound for the debt they're owed, maybe 75p, down to 20, 15, nothing. So it can have a really, really serious implications for the creditor. It doesn't mean that the debt's going to be released, it just means that the order which they get paid in is going to be a lot worse. Just some sort of headline points in terms of limitation periods. Normally the administrator liquidator will have 6 to 12 years from their appointment, depending on some specifics which go around that, and any recoveries they make under these reviewable transactions will be going to the unsecured creditors, so not the floating charge holders. I mean, that's a general position, and all of these reviewable transactions can be found in the Insolvency Act. So the first reviewable transaction that we'll be looking at is the preference. And as mentioned on the slide, this can be brought by an administrator or a liquidator, but not the receiver, so not the fixed charge receiver that Morgan was talking about. And here what we're looking at is a situation where the company does something to put a creditor in a better position in the event of that company going into liquidation than that creditor would have been if that thing had not been done. And that creditor also extends to sureties or guarantors. So to give you an example, company has a creditor who's owed £10,000. Company grants a fixed charge over its warehouse to secure that debt. Now, if the company goes into liquidation and the creditor has that benefit of the fixed charge, when the warehouse gets sold, the sale proceeds will be applied to that fixed charge holder, and that creditor is going to get paid £10,000, provided that there's sufficient value in the asset in the warehouse. In contrast, if they'd never been granted the security, they would be an unsecured creditor in the liquidation, and harping back to that waterfall payment, they're potentially not receiving anything or very little. Unsecured creditors typically do not do particularly well in liquidations or administrations. So that's your general test, but there are some conditions which surround it. So firstly, the company must be insolvent or must become insolvent as a result of giving the preference, the transaction which amounts to a preference. How do we define insolvency? So there's two options here. It's either going to be on the basis of cash flow insolvency, which is the inability of the company to pay its debts as and when they fall due, or you're going to have the balance sheet insolvency, where their liabilities exceed their assets. In terms of the timescale for the preference, this needs to be in the 6 months before the onset of insolvency. And I'll go back to this in a second. So the onset of insolvency will typically mean when the administration or the liquidation process is commenced. And depending, I'll speak in general terms, depending on how that's commenced will influence exactly when that date is. Now, if the company and the party, typically the creditor who's receiving the preference, are connected, that period then becomes 2 years. So the liquidator, administrator can get appointed, and they can look at all the transactions going back 2 years from when they were appointed. Now, what constitutes a connected party could be an entire presentation of its own, but think sort of directors of the company. So the company's given a preference to one of its own directors or a director's spouse, perhaps a controlling shareholder of the company, a company within that company's group, for example. So it's fairly broad, but there are some nuances around that. And again, just in terms of when that preference arises within that 6 month or 2 year period, we have authority of MC Bacon. I thought it was Mac Bacon. I got very excited for a moment. It sounded delicious. But yes, so the time of the James enjoyed that one. The time of the preference will be when the intention was reached, the decision was made to enter into the transaction. So if we think about a company, typically that's going to be when the board of directors hold the board meeting and they say, yes, we're going to grant the fixed charge over the warehouse to the creditor. So it's not necessarily, for example, when the charge document is signed or when it's filed at company's house. So that's the majority of the criteria, but perhaps the most important one is that the company must desire to prefer that creditor, or surety or guarantor, over the other creditors. And this is a subjective desire. So this is where a lot of challengers will fall down, because they need to prove, if we take a company as the example, that the directors entered that transaction and they desired the preference, they desired the outcome, that creditor be put in a better position if the company were to go into liquidation. And often that simply isn't the case. And that's where a lot of the case law goes to. So there's a case called Finnegan, where it was all sort of focused around essentially additional financing being obtained and a preference, security, etc., being granted. And the quote I like is that the intention, the desire of the company in that situation was simply to keep the ship afloat. And I think a lot of companies can relate to that if they're in financial troubles. They're just looking at keeping things going. So whether that is paying a key supplier who's a creditor over other suppliers because they absolutely need the parts or the raw materials from that supplier to keep going, that's their desire, not to give that creditor an elevated status should the company ever go into liquidation. Very quickly, in terms of the ramifications of this, so the administrator or the liquidator would present an application to court, and if the court is satisfied that there has been a preference, they will look to restore the company to its original position. So in the case of the fixed charge of the warehouse, they'll look to remove that. So the creditor suddenly becomes unsecured, just as they were prior to the charge being granted. If monies were transferred, they will seek that they be transferred back, etc. So it has pretty serious ramifications for the beneficiary of the preference. And then one final point is if you have a third party acting in good faith. So this is not the company plus the beneficiary of the preference, but a third party. So if the warehouse fixed charge is transferred on, etc., as long as that third party acted in good faith and for value, so made payment, etc., they cannot be required by the court to pay back into the liquidation or the administration. So that's a very sort of high-level overview. Appreciate time is tight. Right, if we move on,
Tim, before we do that, just looking at that and looking at all those criteria in the round, do you see that is a high threshold for the court to determine that actually there has been a charge given at a preference, or a low threshold?
Based on the case, I mean, it is very, very subjective, and it is going to be heavily based on the facts. But desire is typically quite a challenging burden to get over, just because typically the directors of the company in these sort of situations are just looking to keep the ship afloat. So, if you can make sure you've got board minutes stressing the fact that, this payment is being made to this creditor opposed to the others, despite the financial difficulties of the company, because it's going to guarantee they can put products on the shelves, then those kind of factors will really help you.
So in other words, you should be able to get to a position where you can avoid this unless you are put under massive pressure by that supplier, whoever it may be, to say, I'll only give you this, which is your lifeline, because they're exploiting the position if you give me the charge. And then it becomes an evidential issue. Morgan, sorry.
Exactly. I mean, I think the more, as a creditor, you're banging on the door and demanding security or whatever other type of interest, the less likely it is that the court would subsequently find that there's a desire to prefer. So in many ways, the best way to protect oneself as an unsecured creditor seeking to try to get security is for there to be a bit of back and forth between you and the debtor. And if you're the person banging on the door and none of the other creditors are, and you then get security, you might be, it's still possible that you could be challenged and it could be brought back, but you're in a stronger position than you would be if the debtor had simply given you the security without that back and forth.
Okay, thank you, Tim.
Okay, right. Thank you, Morgan. Right, moving on to the next type of reviewable transaction. I'll keep an eye on the time. So this one, relatively brief. We're discussing void floating charges. So this is where a company grants a charge 1 year before the onset of insolvency. If we think back to the last slide, onset of insolvency, when the liquidator or the administrator is appointed. Slightly more nuanced, but that's in general terms. And where that floating charge is granted for no new consideration. And what is meant by no new consideration is essentially this phrase, new money. So the beneficiary of that floating charge, the charge holder, is not providing new money, goods, or services. It's not reducing the debt of the company to that charge holder, or it's not making payments of interest, etc. In respect to that floating charge. So this is going to be a situation where the company already owes money to said creditor and they just grant the floating charge, and there's nothing back from that creditor, from that now charge holder. In terms of the 1 year period, that will become 2 years if the parties are connected. Again, if we think back to the previous slide, we're looking at floating charges being granted to the director of the company, the controlling shareholder, a company within the company's group, etc. And when the company grants the floating charge, they must be insolvent. And again, we're looking at either cash flow insolvency or balance sheet insolvency. One point to pick up there is if the floating charge is granted to a connected party, there is no requirement to show the company was insolvent when it granted the floating charge. Now, a couple of points to take note of is that when you're granting the new money to try and make sure that you fall outside of this reviewable transaction, you need to do so pretty much at the time when the charge was granted, if not very, very quickly afterwards. So you can't allow for a great delay. And also, if you're providing goods or services in exchange for the floating charge, these need to be at a reasonable market value. So a couple of further points with this is it seems from the case law that it's safest that the floating charge is, the goods, so the new money is provided directly to the company granting the floating charge. So, you wouldn't want a situation where the company is granting a floating charge, but its parent or a subsidiary is the one who's going to receive the new money, goods, whatever it may be. There are certain exceptions for financial collateral arrangements. Again, that would be an entirely different presentation. And though in this situation, the administrators wouldn't need to do anything in terms of a court application, they could simply write to the charge holder and say, we don't consider this to be valid, we consider it to be void. For reasons of certainty, invariably, they will apply to court to seek a declaration that the floating charge is void. Okay, moving on. Right, so we now go into our last two reviewable transactions. Sorry, just flag there are more than four, but these are the ones that we have sought to go through in this presentation. So I will motor through these. So we have a transaction at an undervalue, and this is essentially when the company enters a transaction with another party, and the consideration that they're giving is greater in value than the consideration that they're receiving. So if the company sells a warehouse to another party and they're only receiving £1 for it, that warehouse is worth £100,000, then that is a prime example of something which is likely to be a transaction at undervalue. And so the consideration, monetary value. And so they're looking at where basically the consideration they're receiving is significantly less. In terms of time periods, we're looking at 2 years. So 2 years back from the onset of insolvency. We know that to be when the administration liquidation commenced. There's no difference here for connected, unconnected parties. It's 2 years. So that's when the administrator liquidator will be looking at this. And the company must be insolvent, again, cash flow or balance sheet, when they enter the transaction. If the other party is connected, director, controlling shareholder, etc., then the insolvency will be presumed. It's rebuttable, but it will be presumed. So suddenly the recipient of that property, etc., is going to have to prove that the company wasn't insolvent. There is a defense to the company for this, where essentially they acted in good faith for the purpose of carrying on the business, or at the time that they entered the transaction, they had reasonable grounds for believing the transaction was beneficial. So if we think, for example, they sell a piece of land which they thought was largely worthless, and then it later transpired that it had oil underneath, that's not necessarily their fault. They were acting in good faith, and they thought, great, we'll flog this piece of worthless land. It will get us £100. That's at least that's money, etc. A further point to note is that the court can still refuse an order, which would obviously be to unwind the transaction, if they consider it just to do so. We see this more in a bankruptcy situation, typically in a husband-wife scenario, but there is that discretion of the court for that. And lastly, much like with the other examples, if you have a third party in the chain, so company, the beneficiary of the property, for example, they then sell that property on to an innocent third party who purchases, let's say, the land in good faith and pays good value for it, then they generally won't be made to contribute back to the company. There is an exception if they're, for example, connected with the middleman, or if they were on notice that the company was insolvent, etc. So just noting for, I don't think I will have time to go for the case law. There's a bit of lack of clarity as to whether granting security, so a charge, for example, could amount to a transaction at an undervalue, because there's question marks about whether you can place a monetary value on the charge itself. Yes, I will probably leave it there. The only other point is that the court will consider, there's a series of linked transactions going on. They will consider the consideration cumulatively from all of those transactions. So it may be that they only paid £1 for the land, but then they entered into a separate but related agreement where they paid £100,000 for something, and so that will be taken in the wider context. And then very quickly, transactions defrauding creditors. This is it's the same TUV test. So are they receiving consideration significantly less than they have given? The difference here is that the company doesn't need to be insolvent or necessarily in administration or liquidation. A victim can bring that claim, but the new factor is that the purpose of the transaction, so the reason why the company entered into that transaction, was to put the assets beyond the reach of the party who's looking to make the claim, or to prejudice the interests of such claims. So essentially, there's a fraudulent element there. Again, much like the preference, to find that purpose, it has to be a subjective. So you're looking at what the directors actually thought, not what a reasonable director would have thought in those circumstances. And again, if the court grant the order, they're going to revest, they're going to undo the transaction. Right, mindful of the time, I will skip on to the last slide. And Morgan, I will hand back to you just to fire through some of those security tips.
Yeah, just well, the first one is so with clawback risk, obviously there's the risk of the transaction being clawed back against the beneficiary of the transaction. So if you have a TUV or a preference and it goes in favor of an entity, there is the risk obviously of clawback. But if the directors have allowed the company, the debtor, to enter into the transaction, there is also the risk of personal liability for the directors themselves. And so if a director grants security preferentially, or if it's a TUV, as Tim was talking about, although there's a debate about that in the case law, that is potentially a breach of the director's fiduciary duties to the company and puts the directors potentially at risk of personal liability. And in the event that the company, the debtor, subsequently goes into liquidation or administration, there is a risk potentially of being disqualified from acting as a director in future. So it's very important for directors to try to, as best possible, to act when they're in an insolvent scenario where the debtor is insolvent, either on a balance sheet or cash flow basis, to act for the benefit of all the creditors as a whole, rather than preferentially acting to the benefit of one creditor over the others, particularly in a situation where, for example, one of the creditors is connected to the debtor and they're seeking to give security to the creditor simply because of the connection between the two entities. So it's not just an issue for the party obtaining the security. It is an issue for the directors themselves, of the directors of the debtor as well.
Okay, we'll just fire through the last ones just so we have time for a couple of questions at the end. So as illustrated in the previous slides, if you're granted security, it really does need to be for new money. So just because you were lent £100,000 6 months ago, you shouldn't subsequently be granting security. Obviously, void floating charges is one risk. Preferences are maybe another. So directors should be mindful of that. Directors should also think about the benefit of granting security for the company. So typically, especially in these group structures, you'll have subsidiaries and parents providing guarantees or charges in respect of another company in the group's debts. And that may not necessarily be in the best interest of that company itself. So they should absolutely be mindful of that. And then lastly, this is more a point for if you're a borrower and you look like you're going to default. It's about having that early dialogue with the secured creditor to try and explore refinancing options. And this is hopefully when you'll get solicitors involved to facilitate that process, just so that you can avoid enforcement and all the costs which come with that. You do not want the secured creditor taking actions to present winding up petitions or seek to appoint administrators. You want to try and negotiate early on and avoid all of that and avoid the reputational harm to your business which would come with that. Okay, right, I think, sorry, we are running slightly late, but we'll be very happy to open up the floor to any questions.
Thank you, Tim. Morgan answered an earlier question, so I've got a new one. Do the members of an LLP have the same things to consider as directors of a limited company when granting security for a loan to a third party, a loan to members, for example? So is it any different in an LLP situation rather than in a limited company situation?
The same principles apply. So effectively, you could be at risk of effectively breaching your fiduciary duties as a member of the LLP, and there could be the same preference risk in the event that the LLP subsequently becomes insolvent. So it raises basically very similar issues.
Okay. Right. In the absence of anything else new, I'm going to say, well done, chaps. Thank you very much. Thank you to Tim and to Morgan. I've learned a lot about security today. Very illuminating. Thank you, everyone, for your attention, and thank you for those questions. There'll be another In-House in Focus session coming along shortly, but we will be taking a break for the summer holidays when they arrive. And I would just like to say thank you very much and remind you, as you leave, please do complete the feedback form and let us know how you thought it went, only if obviously it's a 5 stars, which is what they say in all the podcasts that I listen to. So subscribe and listen, which is what they also say. There you go. That's enough of me. Thank you, everyone. Take care. Bye-bye.
Thanks so much, guys. Goodbye.
Thank you for listening again.